Well, welcome to our third episode in the Financial Poise series entitled Life Sciences and the Law. This episode is going to focus on how you begin. Life sciences startups are just different from other startups. So much depends on the type of technology being developed, the personal strategic goals of the founders, the specific product, the competitive landscape, and even where the technology was created. Before we get started, let me make some introductions. This webinar is being brought to you by Financial Poise, which provides practical and entertaining education for attorneys, accountants, business owners, executives, and investors. You can read more about Financial Poise on slide 51. Our panelists today are Ed Amer, a Goodwin corporate partner in the private equity group, Matt Ferry, a Morrison and Foerster corporate partner in the technology transactions group, Ed Pease, a corporate partner at Mintz Levin in the venture capital and private equity group, and Bill Walker of Boundless Science, who also until recently was the director of engineering entrepreneurship at Duke. And Bill is just a serial entrepreneur as well. My name is Jay Riley. I'm a corporate partner at Foley Hoag in the licensing and emerging companies practice groups. You can see who we are on slide 5 of the presentation. You can read our bios on slides 45 to 49. Neither Financial Poise nor we intend for this to be an infomercial, so we're not going to take 10 minutes. We're not going to tell you all about ourselves. We're going to dive right into the content. So if you do want more information about any of us, please do feel free to go to the end of the presentation and look at our bios. Now about the slides, we've put together a deck, but we're not going to be going through this slide by slide. This is really going to be more of a conversation. The presentation is loosely going to follow the slides, and I'll try and call your attention to some of the slides whenever they're relevant. But frankly, this is going to be a lot more of a discussion. So if you're listening to this webinar and not watching it, you're going to be just fine. The slides are not critical. However, if you do want some more in-depth information, please do feel free to refer back to the deck. We want to give a big shout out and thank you to our co-producer, the National Law Review. It's thanks to them that we are able to be here today doing this for you. You can read more about the National Law Review on slides 3 and then again on slide 50 at the end of the deck. The last thing before we begin, I want to make sure that you take note of slide 4, the disclaimer. You're not our clients, we're not your lawyers. What we're doing here today is for general education. It's not for you to act on without appropriate legal advice. So now, without further ado, let's dive in. As I indicated at the beginning, all startups have fundamental similarities. You know, the entrepreneur is often starting a business for the first time. Startups are always looking for money, but life sciences companies are different. They've got several characteristics that make this a completely distinct industry. Products take years to get to market. There's an enormous amount of capital that's required to get products to market. The risks are just enormous. The reward can be huge, but often there's an exit without any reward at all. Patent protection for products is just paramount. The development and exit strategies can vary wildly, depending on if the product is a platform technology or a single asset. Manufacturing considerations can dramatically influence product development and commercialization strategies. So there's a lot that really influences life sciences startups as opposed to technology startups. So we're going to explore corporate formation and the first steps that you're going to take as a life sciences entrepreneur with all of these factors in mind. So let me dive in, and Bill, let me turn to you. You're the entrepreneur in the room. With all the hats that you've worn, you meet with a lot of life sciences companies at the very beginning. When you've got an inventor in your office wondering how to get started, what do you tell them? I guess the first question is really, what do you tell them about the team that they should be putting together?
Yeah, Jay, before I even get to the team, my favorite question is, tell me about the problem you're addressing. And that sounds, to this audience, that probably sounds silly that somebody could think about founding a company and have to be asked about the problem they're addressing. But in academia, it's just not how people think necessarily. And I've had just brilliant people take an hour and not be able to tell me the problem that they think they're going to build $1 billion company around. So that's actually step one. And let's say they get over that hurdle and they can actually define the problem and what human being it's going to address. Then I start to talk to them, okay, you're going to need a team to do this. You can't build a breakthrough company as a hobby on nights and weekends. So what does that team need? Not surprisingly, you'd think it wants somebody who has venture experience, not necessarily big corporate, but somebody who's been in a venture, been has started something, knows how to build the systems that are required, knows how to interact with investors. Usually, the founders I deal with are technology experts, so they're PhD scientists, engineers, and so they say, okay, we got that covered. So they've got a venture person, a technology person, but what they're missing, and they don't usually realize it, is a product expert. So one of the things I've learned the hard way myself and seen learned the hard way by others is that technology is not product. The ability to master a technological domain does not mean you can build a product that will get through regulatory and treat patients and solve real world needs. So I encourage people to build out those minimum 3 element teams: venture, technology, product, and almost no individual can cover all 3 of those. So that's one of my early pieces of advice, Jay.
So, Bill, let me follow up and dig a little bit deeper. So, you've got 3 pretty different personality profiles there of your perfect profile team. How do you make sure that their goals are aligned, their values are aligned? How do you get the right mix of people together?
Yeah, so that's a great question, and I tell people I'm on my 4th company, and I founded every company with friends, and out of those like 7 friends, I've still got one of them. So that's what happens when you don't align your values and your exit strategy. Early on, people have to talk about, what do you want out of this? Do you want to build a company that you have a hand in for the rest of your life? Or do you want to grow something fast, sell it into a big player who can scale it commercially and treat as many patients as possible? It's amazing how often people don't have that conversation. They just assume everybody at the table wants the same thing, and that'll kill you. Um, I do encourage teams to talk about values really early on, and I draw a really important line. Values are not aspirations, right? We all have aspirations, we all have hopes and dreams and things we wish were true. But a value is something that when the rubber hits the road, you're willing to sacrifice other things to live up to that. And it's really important that you talk to your team early and understand where those boundaries are. We just did a sort of, I'll call it a value summit at my current startup, with everybody on board and everybody in hand. And we spent an hour going over the values that our leadership team believes in, and what we want. And we got buy-in from all the junior people. And then I looked at one of the junior people who's, he's only 35 years my junior. And I said, hey, you said you believe this is a value. Are you ready, if you see me break it, to call me out publicly and stop me? And everybody in the room kind of pulled back from their chair a little bit. And I said, because if you're not, this is not one of our values. It's just an aspiration and a hope and a dream. If you are, then we're all on the same page and we're going to achieve great things together. And not only will we achieve great things, we will feel fulfilled and whole in doing it. Because, I've exited a couple times, but it's pretty sad when you exit and you no longer enjoy the people you've been working with because misalignments of values caused a lot of conflict. So what people don't appreciate is explicit values help you have a happier, healthier work relationship.
Great, great. So thanks. That's actually really helpful. I think that's actually going to inform a lot of the other topics that we're going to cover today. So let's, all of us keep that in the back of our minds as we're talking through things like formation and exits and hiring and incentivizing. That's a really great theme to carry through. Ed Pease, let me turn to you. Let me ask you sort of a little bit of a more mechanical question. When do founders need to make it official? What triggers needing an entity, and what do founders do?
Yeah, very good question, Jay. So Bill and his friends are sitting around talking about the next great venture and sort of when do you make that real and what are the key inflection points for that. First off, I would say let's remember why we form corporate entities to begin with, to limit our own personal liability. So if you're about to enter into any sort of contract that could result in you breaching that contract and causing damage to someone, or You're going to be engaging a consultant to do anything that you're going to be asked to sort of have a contractual obligation. It's probably time to spend the short cash necessary to form a corporation or an LLC, and we'll talk about those in a moment. But first and foremost, we want to make sure we appropriately limit our personal liability. And so if there's anything that's arising there, time to get serious and form the entity. Short of that, there are some other inflection points we should talk about. Bill and his friends are getting together and they're talking about ideas. They're talking about basically the future intellectual property of this company. Without an organization, without a corporate entity, and an assignment of that intellectual property by those individuals to this corporate entity, the intellectual property of the company walks out the door each night when they're done talking about their ideas, and everyone owns them and no one owns them. So if you are building a business based on intellectual property, as most life science companies would, it would behoove you to form an entity and have the individuals that are creating that intellectual property assign the intellectual property to that corporation or LLC so that it actually has those intellectual property assets owned by the entity. Another inflection point is Bill and his friends are sitting around talking about who's going to own what of this entity. And great, you're a genius. You have 40%. You're going to be the CFO. You'll have 10%. You're going to have the other 50% because you're the scientific founder, whatever that is. As we talk about dividing the pie, you need to actually create the pie in order to divide it. So forming the corporation or the LLC and giving out the interests is important so that people understand their various ownership stakes. Also important because as the value of whatever you're incubating grows, if I then issue equity after I've created significant value, there may be negative tax implications to that. If I give myself 50% of a company that's already worth, some amount of money because of the value that's already been created. So best to do it sort of early on and in the process so that you avoid any of the problems that could arise if you don't. And there's also the sort of let's get serious factor and the step of forming the corporation and spending the $1,000 or so dollars it might take to set up the entity causes everyone to get a little bit more serious about what they're doing. And then just quickly how you set up or what sort of entity you set up. Typically in an early stage life science company, it's either going to be a corporation or an LLC, and that's going to be driven largely by tax considerations. Corporations would have the sort of the double tax structure. So if you have any inkling of making earnings and profits that are going to be taxed, you might think about an alternative to just the C corp, and then LLCs provide a little bit more flexibility as a pass-through entity. We could spend hours on both of those, but that's the high-level look at how you think about when you start and what you might start.
No, that's great. That's a really helpful overview. Let's drill down on that a little bit more. Ed Amer, what do you see in terms of the different ways that you do structure life sciences startup companies? And to what extent does the exit strategy influence what it looks like from the very beginning? What is the right mix of corporation or LLC or ownership interests? And can you tell us a little bit more about entrepreneurs who are facing setting something up? What do they choose?
Yeah, and to Ed's point, we could spend hours on this, but I'll try not to. Just try to spend a few more minutes. As Ed said, the major difference are an LLC is a pass-through entity for tax purposes, which means that the profits or losses are not taxed at the entity level. They pass through and they're taxed to the individual members, the owners of the LLC, whether or not there's actually cash distributed. usually in life science companies, there's a long road before any, especially particularly therapeutics companies, there's a long road, a decade or more, before there's any revenue or profits. So you're talking about allocating losses. And so for some founder groups, if you're going to be putting in money and generating losses and you want those losses to pass through to you so you can offset other income, you might like to structure it as an LLC initially. You can always flip to a corporation if you know sort of based on the investment profile or the exit strategy that you're going to want to ultimately be a corporation. It's always easier to start out that way, but there is ability to flip back and forth as needed. I would say to sort of make the right determination, it does make sense to look both towards the likely investment trajectory and your potential investors, as well as the ultimate exit goals. So some investors just can't invest in LLCs, and I would say as a broad category, institutional investors, pension funds, and other tax exempt investors who are often represent a large portion of the limited partners in a venture fund, won't be able to invest in a pass-through entity, and so they will need to invest in a corporation. Sort of there's an asterisk there. They can't invest through an LLC if it's passive, if there are no operations in it. So I would say that's one consideration. If you know you're going to look to VC investors in the near term, you might just want to start out as a corporation. A sort of more advanced structuring play that we see more and more often is an LLC holding company on top with multiple corporations underneath, with each corporation holding an individual program, therapeutic program. And with that structure, that allows multiple exits. You can sell the individual corporate subsidiaries that each just, again, hold a single therapeutic asset to pharma companies. And that's a structure that allows, if your company, if the sort of, the premise of it is that you have platform technology that's going to generate multiple assets that you're going to want to sell to different buyers. That strategy is, that structuring is very useful and facilitates that result.
Great. You know what? Let me drill down on that even more. Because this is so important. We set so much in motion when we set up the corporation. Matt, you do a lot of work in structuring these exits. We've been talking about exits. We've been talking about sales. We've been kind of sort of, alluding to it. Generally, can you tell us a little bit more about what do we mean when we say exit in a life sciences company context?
Yes.
And really, how do the different exits really play into the corporate entity selection?
Yeah, sure thing. So exits in life sciences means a lot of different things. Typically, that means in a more of a tech-centered focus. In life sciences, like my colleagues are picking up on, you live, breathe, and die by your technology, your patents, and your IP. That's not always true in other sectors, like in life sciences. So your exit may take a little bit more of a nuance. It could be through an entity exit, through just selling the corporation, selling the stock, could be an asset sale, or it could be various spin-out transactions, where if you have different subsidiaries selling off the stock, like Ed was talking about, or granting exclusive licenses within certain fields. All of these become various forms of doing exits, and the border between what's an exit and what's a commercial contract is very fuzzy in this area. When it comes to what you need to do as far as the structuring to get things right, I like to think of it in terms of two things. You want to be very interesting on your science and your business, and 90% of the time, very boring on your legal. So if you have very interesting things about your legal, that's probably not a good thing. A buyer or an investor will want to see this as pretty vanilla, nothing to see here, folks. Let's keep moving things along. Now, oftentimes, if you're a platform, you'll have some more of a hub and spoke structure. But if you're just a single therapeutic asset company, let's keep it simple. VCs like Delaware C Corps, unless you have a really strong reason to do something other than a Delaware C Corp, I don't see why you would necessarily. And then as far as getting things off the ground, the two things you have not enough of that you need, and when you're in the early stage life sciences, are time and money. And you don't always have enough of it. So I like to prioritize between what has to happen now to get it right that's really hard to clean up later versus things that could happen later in order to optimize for your particular exit you want to do. So in the beginning, you want to keep your freedom for a variety of exits that might come down the pathway there. And for that, it's really the meat and potatoes aspects like Ed and Bill were talking about for making sure the company actually owns the IP, making sure everyone who works for the company has properly assigned their rights in the patents to the company. Any contractors doing work for you have assigned the rights. If there's an in-license from a university, making sure that's properly buttoned up. Things that are very hard to fix later. If your co-founder leaves or if your employees leave, getting them to sign something can be very difficult to do in order to properly get the rights. As far as structuring, whether you're an LLC, C Corp, a lot of that can be changed later. Sometimes it can be expensive. Sometimes it might be a little bit harder to set up, but it is fixable versus some things in the beginning just are not. The main things that you want to have is be boring on the IP side is proper chain of title, proper allocation of rights, and you don't have any major restrictions on your business to operate in a variety of spaces. Sometimes it might make sense to do an early deal with an exclusivity, but it has to be a very weighed decision of the cost benefit for that particular deal.
Great. Thanks for that. I want to come back to something that Ed Pease, you had alluded to a little bit earlier. You were talking about the allocation of equity amongst founders, and then you sort of slid into a discussion of what equity is and what that means. But if you've got a series of founders at the table, what tips do you have of how they should be allocating equity? And for those of you who are following along, we're looking at basically slides 17 and 18 at the moment.
Yeah, thanks, Jay. So, this is a question that gets people tied up in knots, right? You've got a couple of team members, and maybe they're actively involved in the business. And if it's a life science company, maybe there's an academic at an institution that is an inventor or technology coming out of their lab, and you need to figure out how do these people that are going to operate and turn this into a business, how do they square ownership maybe with the academic who's going to remain at his institution, or it's just two founders coming together to start a business for the first time and they think, hey, great, we ought to own the company 50-50 because we're two guys starting a business. And so talking about how to divide founder equity and what to value in assessing who should own what is a very important topic for any startup company. And what I like to do is counsel them to just sort of honestly assess what each founder is going to contribute over the next several years of the company. And not focus so much on what's been done to date, but look at, okay, you have this kernel of an idea of a company. It's going to take an awful lot to get this to something that you can exit from, or that's going to be an interesting business to someone else. Now, certainly some businesses grow faster than others, but in the life science world, we know this is a long-term, slow burn off and can take years to percolate. So talking about, who among that founder group still going to be here 4 years from now or 5 years from now? What skills do they have? What skills are they missing? How big is their contribution going to be? And are they going to stay involved? So just trying to get folks to honestly look at what their skill set is, what they're going to do, as the business grows to contribute to that growth, rather than, hey, you had this great idea, but you have absolutely no idea how to turn this into a business. You have no business experience, and maybe you're not the right guy to be the CEO here. So perhaps you shouldn't have the 50% stake. So I always want to have them sort of think out and look going forward rather than overvaluing past contributions and saying, oh, I've been cranking away at this for a year, in my spare time, so I ought to own X% of the company. I also would caution people to avoid a 50-50 even split, just because that that's going to invariably lead to dispute. I would say probably the number one thing that I think derails startup companies, besides bad ideas and no market fit, is misalignment among the founders and some sort of founder dispute. Everyone loves everyone at the outset of these projects, and when the going gets tough and they realize it's awfully hard to start a startup business and make it a success, problems can arise. And so that's another, I know we'll talk about this a little later on, but that's certainly a reason for whatever determination you make on founder equity. Make sure that it's subject to some vesting and that people have to stay involved in the company in order to earn that that equity and keep it. Because if you and I started a business and we split it 50-50 and I get a nice job offer from Google 3 weeks later and I leave with half the business, it's going to be hard to incent you to get up in the morning and create a fantastic business for which I'm going to get 50% of the benefit for doing nothing. So certainly subject to any founder vesting or any founder equity to vesting, and really just honestly try to assess your skill sets and who is going to, who among the founder group is going to be around and have the skills to execute and build this into a going concern, and not just being an idea person. And I would say quickly on the academic front, I deal a lot with misalignment from the academic with the idea who's not going to actually participate in the company at all, and their outsized expectations of what their equity ought to be. And I would say, try to keep that as minimal as possible, given that they're really going to be making no continuing contribution to the company. And a lot of investors will look at your opening cap table, and if there's a non-active founder who holds, any sort of significant stake in the company, they're going to have a problem with that and say that, the people that are doing the work every day ought to be the people owning the company in significant amounts, and not an academic who might have had a great idea, but isn't going to be doing anything on a day-to-day basis.
Yeah, I've heard you say, Ed, and it may be on the slide. A great idea is just that. It's only that it takes execution to actually build a company and to build a business. And so that's really got to take the lion's share of the credit in terms of allocating equity. Bill, you've worked with a lot of founders. Any war stories, any tips, any recommendations that you would give?
Well, Jay, we don't have 8 hours, so I can't share war stories. There's just too many. But I think Ed and I try to get very much to the same place, but I try to turn it into a problem for the founders to work for themselves. I work with academics a lot, and they believe that they can suss out anything if you give them the right rules. So what I do is I sit down with all the founders in a room and I say, tell me today, if we're going to found the company, Ed's going to file our paperwork on Monday to found the company. As of Monday at 8 a.m., what fraction of the net value of this company has been created? And if they come back and tell me any number higher than about 20%, I tell them, all right, let's sell the asset. Because you've got decades of work ahead of you. And if you've already got 20%, you've done all the heavy lifting. So let's sell the asset. How do we do that? And then they usually fall back, or they say, well, really, it's more like probably 10 or 15%. I say, okay, so what we know now is pre-founding, pre-company creation, 15% of the equity was earned. Post-founding, 85% is to be earned. Now, you three founders, Alice, Bob, and Carol, I want you to kind of write down on a piece of paper what fraction of what happened pre-founding you think you accomplished, you personally delivered, and what fraction post-founding you think you personally are going to deliver. And it's interesting when you break it down that way, the I need to have 50% of the company thing, it kind of fades away, because now people have to justify it. It's not a want, it's a justifiable position. And what I find is that those negotiations, everybody pretty quickly agrees. And when they can't agree, I see a company that's going to have huge problems ahead, because people are not living off the same fact base. So then I say, okay, great. At founding, we're going to allocate 15% of the equity with the formula that you all just agreed to. And then the rest, the other 85%, is going to vest over 4 years. And they say, why not 3 years? And I say, I don't know. It's all made up. This is what the market says these days, 4 years. So we're going to do 4 years. And then the other piece is I tell them, you probably need to have a way to fire each other. So in my current company, there were 3 founders on the first day. And I insisted that we have a way to fire anybody who wasn't working out. And it was without cause. 2 out of 3 founders could say, we're going to fire the other guy, and his equity will cease to vest on that day, and that'll be that. And in fact, 7 months into the company, we did. We decided that one of the founders didn't align with our values, didn't align with our vision, and didn't play nice with others. And so we fired him. So not only am I a big fan of vesting and not equal shares, but I'm also a big fan of build in a plan to break up the leadership team in a way that's honest and decent. But I mean, nobody wants to get up every morning and feel awful about going to work.
Oh, great. Good advice. Well, let's pivot now to talk about funding life sciences company. We're going to be doing a session on October 7th of how to fund life sciences companies in a deep dive. I don't want to get too into the weeds. But life sciences companies have some unique challenges, but also some unique opportunities when it comes to getting funding. So I just wanted to touch very lightly on that in this session. Matt, can you tell us a little bit about the various sources of funding that are available to life sciences companies?
Yeah, sure. And Jay, I totally agree with you. Your spend and your burn is a lot higher than if you were a tech or just an app company that's out there. But the world has adapted to allow for that also, just recognizing that there's a need for therapeutics and for life sciences companies generally. So I like to say there's a variety, really a bucket of 3 or 4, depending on how you look at it. So in one, you have non-dilutive capital. Also, you have federal grants, you have NIH or SBIR grants, or foundations who give grants. Sometimes there'll be some strings attached to it, and especially with government grants, be aware of the strings that come with the Bayh-Dole Act that way, and the government obtaining a license. There's also just the dilutive equity piece as well. So friends and family or angel in investing. I'm sure you'll hear a lot more about that. Then also a variety of what I call hybrid structures, where you're doing an early stage deal with a commercial partner, or perhaps they can fund your research and development a bit in exchange for some future rights or something else. And for that, the world's your oyster. See prior discussion talk about not giving away too much at the beginning, because you want to make sure you have something, but at the same time, it's better to have a piece of something than everything of nothing. So you need to have a business to worry about to begin with there.
Very good. Very good. I get the question all the time. I'm raising money. The investor wants to know my valuation. How do I demonstrate my valuation? Do I need to actually get a third-party valuation? What do I do to prove my valuation? My answer is always a hard no. There's a place for valuations, but not when you're raising money. Ed Amer, can you tell us a little bit about what valuation means, how it works in the mechanics of a financing, and how it sort of controls the dialogues and the most basic of the terms of the financing?
Sure. Yeah. So I would say the most critical business point you're going to negotiate in an investment term sheet is the pre-money value, and that's the value the investor ascribes to the company before they invest, and that'll determine what they pay for whatever percentage of the company they get. So, for example, if you negotiate a $10 million pre-money, you convince the investor your company's worth $10 million before they put any money in. For $5 million, they're going to own a third of the company. Now, how you get to that valuation, it tends to be more of a negotiation and doesn't really lend itself to a third party appraisal, because typically at an early stage of a life science company or therapeutics company in particular, the actual sort of revenue is so far off in the future and so at risk that it becomes more of a negotiation based on what other companies have achieved at a similar stage from VC investors. I would say maybe another wrinkle to that is when we say, okay, the company is worth $10 million currently, and so you could divide 10 million by the by the current equity to determine the share price the investor will pay for their investment. There's another negotiation about what's included in that capitalization, and there's always a negotiation around the investor will say, well, yes, you three founders own all the outstanding equity, but we know we have to add people and we're going to have to add a 15% equity incentive pool in order to add team members, give them incentive equity, and build out the team. And that 15% goes in the pre-money, which decreases the share price the investors are paying. So that's sort of a corollary negotiation around the pre-money value, what gets included in the pre-money capitalization.
Okay. What if you just can't figure out what the pre-money valuation is? What if you just can't come to an agreement on the valuation? Ed Pease, can you talk a little bit about some of the other tools that are in the toolkit of other fundraising mechanisms that can be used?
Sure. So two primary areas that you might see to bridge the gap between valuation expectation and what investors are willing to pay or ascribe to the value of a company, and those are the convertible note and the SAFE or simple agreement for future equity. And in either of those investment securities, the company does not need to establish a valuation today, and rather it is an early stage investment that says, I will make an investment today in the context of a convertible note. You will pay me back X amount 1, 2, 3 years from now, or you will convert the amount of capital that I've given you plus some interest rate into the equity of the company when there is a financing of a certain defined round. So the investor is basically saying, we don't agree on valuation today. We'll punt until a later date when you get a lead investor, when you're far enough along to have a valuation expectation that meets with an investor's expectation. And when that financing round happens, my capital from the convertible note is going to convert into that financing round. So ultimately, my convertible note investment ends up being an equity investment. I just am sort of delaying the valuation of that. And my reward for delaying the valuation is I'm typically going to get a 20% discount to the price being paid by the folks in the financing round that triggers my convertible note conversion. And out of some concerns about California lending law, which were there and then sort of later done away with by the California legislature, grew the West Coast phenomenon that then spread to the East Coast, the simple agreement for future equity, which is not a convertible note. So it's not a loan. There's no obligation to repay the company. It simply says, I'm going to give you X number of dollars today, and you're going to convert that in the future when this equity round happens into equity at that time. So there are two, sort of widely accepted uses of instruments to bridge a valuation divide and sort of defer that discussion till later, till the company has done A, B, and C, and now can raise a bigger equity round with a lead investor who's willing to pick a valuation at that point.
Great, thank you. As part of raising a financing round, so many investors are really looking for a snapshot of the company. And, we see decks in what we do all day long. We look at the investment deck, so the first thing that I ask a potential entrepreneur is, send me your deck. Let's take a look. Let's see how you're pitching yourself. Let's see how you're positioning yourself. It's the first look that an investor is going to be getting of your company and of you, and you will be judged in the first 10 seconds of them looking at the deck. The deck is your elevator pitch. The deck is the thing that you will be able to use to either put your best foot forward or, potentially kill your chances of getting financing. Bill, you have helped countless companies with their investors decks. What is the deck? What should be in it? What pitfalls should investors be, or should the companies be avoiding to make a good impression with the investors?
Yeah, Jay. So I love the format laid out by Guy Kawasaki. Kawasaki was a designer at Apple, and he basically has the 10-slide deck. But the part that's important is the first three slides. And what you said at the beginning was right. You've got about 10 seconds to grab people. I tell people that investors have pretty bad ADHD, and mine is worse than theirs. And so you better engage me and entertain me from the first second in. And I really want to see three slides. I want to kick off with the problem, and I want the problem to be visceral. I want it to be scale. I want it to be large, and I want it to matter. And in an ideal world, that problem slide teaches the investor something about a problem they weren't fully aware of. So they go, oh, this person has some insight about this space. And then number two is the solution. It's the product you intend to deliver, whether that's a therapeutic molecule or whether that's a medical device. What's it going to look like? How's it going to work? How's it going to solve the problem? And slide number three is why your approach is the one that's going to work. The magic in what you're doing that matters. My last company, Hemasonics, our third slide was sort of three key innovations. It was a key innovation about how we measured the key parameter. There was a key innovation about how we displayed that parameter. And there was a key innovation about how the workflow worked based on a consumable that we had designed. So problem, solution, magic, grab them by the lapels, get them really excited. You should be able to pound through those slides in no more than 5 minutes. And ideally, they're asking you questions as soon as you're into that stuff. I'll tell you the things I hate, the things that I think ruin a deck. Let me begin by giving you an outline of my deck. It's like, when was the last time a movie won an Academy Award with a plot summary up front? Just never, and it never will. And the other one is, let me start by telling you about my team. I care about what you're going to do. If you're not on to something interesting, I don't care about your team. And if you're on to something interesting, then I'm going to pay attention to your team all day long. So, for me, go at them hard with problem, solution, magic. Give them a sense of the scale of the market without getting down in the weeds. You don't need to go into 8 market reports to convince me of your market. I want to see a bottom-up estimate that tells me what it's going to look like. And understand that all those market estimates are order of magnitude guesses. They're not real. They can't be real. Product doesn't hit the market yet. So that's my sort of basics, and everything else you have up on this slide is all correct there too. But I feel like you got to really grab them at the very beginning and get them excited.
Great. Good. Thanks. Let's pivot to talk about intellectual property for just a minute. Again, we're going to be doing another IP session on November 18th, so I don't want to go into too much detail here. But there are a couple of things that you want to make sure that you get right out the gate as you're beginning the life of the company. So I do want to spend a little bit of time just touching on that. Matt, let me throw you a softball here. Just how important are patents to a life sciences company?
In case it wasn't abundantly clear from my previous answer, the answer is very. Life sciences companies, like anyone else, unlike other industries, will live, breathe, and die by their patents. If the patent world went away, tech might be, in some areas, happy, some areas sad. Life sciences industry would just die. It just wouldn't function anymore. So absolutely essential for the patent, or I think it's absolutely essential to have a coherent IP strategy, of which patents are probably going to be the most fundamental piece of it. Investor due diligence is really going to center on that and on the IP itself about, are the patents worth anything? Is the invention actually patentable? 2 is, do you own it, or do you have the proper exclusive license? And then 3 is, can you defend it if there is a challenge to it? So essentially, I like to counsel founders that on day 1, you should really have 5 different things. You should have your documentation for your conception of all your inventions. So if you have all of the raw material necessary for your patent portfolio, you should have all your assignment agreements executed with the proper language in order to have that transfer from the individuals to the company. And it can be some non-trivial, so have some competent counsel, not necessarily me, just anyone advise you about, it has to have hereby assigns in order to properly transfer the title over there. 3 is making sure your filing strategy is going as early as you reasonably can. And the United States has now matched up with the rest of the world as a first to file. So if you file, you're saving your place in line at the patent office. If you do a disclosure before you file, you have potentially lost your rights in Europe and you've started a clock in the United States before you can actually file. So making sure you're getting your patent applications, your provisionals on file early. 4 is having that patent landscape and freedom to operate map created. Then that may be either more formal or less formal depending upon your stage in development. In my experience anyway, in the early stage fundraising, it's not as critical to have anything formal, but it's a good idea to have at least that initial look to see, am I going down a road of this is going to be a problem for me later, or is it okay? And then also coordinating between IP and publication. You want to be garnering interest on the business side with your publications, but having that also coordinate with your filing strategy so you don't accidentally shoot yourself in the foot there. So while patents are most important, the second most important, I'd say, is trade secrets and making sure your data and everything is properly tightened up and having the right physical, administrative, and technical safeguards on your core information, and any agreement that you have with someone else that discloses it has proper confidentiality protections there.
Let's talk a little bit for another hot second about trade secrets. So many of my clients think that trade secrets are just confidential information, and with a CDA, they are protected. There's some statutes that actually govern some specific requirements with respect to trade secrets. Any tips on what people should be doing with respect to really calling out those trade secrets and specifically protecting them?
Well, there are, a trade secret under the law is protectable so long as you've done 2 things. So long as it maintains value from not being generally known to those in the art, and it is subject to reasonable efforts to maintain the secrecy. And that is a big prong. That means a lot of different things under different circumstances. So Jay, you are totally right. They have to be taking what's called reasonable efforts under the law in order to protect it. That does mean the agreements, but that's only really a first step. Anything else that if you were to show it to a judge or jury later to prove that this was being taken to protect the confidentiality would be essential. So marking it as confidential, only sharing with certain people, only giving access rights to certain individuals within the company even, all those can really help the issues later on.
Okay. Do you actually need a special trade protection policy, or is it sufficient for your clients to just follow some of those steps that you're talking about?
It's definitely advisable to have something. So whether it's a written policy would probably be the best because it's going to be evidence of what you typically do. But you also have to follow it. If you have a written policy but you're not following it, it's not going to really mean anything. So having a written policy, whether it's about whether you call it a trade secret policy or an information security policy, something like that would be very helpful to have. In your agreements with any sort of employee or contractor, it's helpful to have the DTSA language, which is the Defend Trade Secrets Act, which if you don't have it, limits your remedies available if there's a trade secret misappropriation later on.
Great, great. I'm actually going to jump in here myself and just make a quick point. When you are contracting at the very beginning, you will want to get an assignment of intellectual property rights from your contractors, from your service providers, from third parties, assigning you the ownership of that IP. And so many times in M&A, at the exit, at the out license, when another party is doing due diligence, there's a hiccup in the transaction because they come across contracts that have been responsible for the generation of intellectual property for which the assignment of IP provision was not sufficient. So you want to make sure that you get this right from day one, because fixing it after the fact can lead to problems. You can have to pay ransom to the service provider to get the future assignment of IP. You can run into issues where the people just aren't available to assign the IP. Can really cause problems. So for those of you following along at home, we've got slide 32. For those of you who are listening, make sure you download the slides and go to slide 32. For you to own the IP that's been created by somebody else, the contract must say, we the contractor hereby assign to you all of the rights, not just in the deliverable, but in all of the intellectual property that underlies the deliverable. And you need a present assignment. If somebody says that we will assign to you the IP rights underlying the deliverable and the deliverable itself, they haven't assigned it to you. And you then need that second piece of paper going back and getting the assignment. Nobody ever does that. So you want to make sure that your contract does actually say, I, the contractor, do hereby assign to you all of the rights in the deliverable and in all of the intellectual property rights underlying that deliverable as well. But we're running a little bit short on time, so I want to move on a little bit to advisors and employees and talk about what that looks like for for you as founders just getting started, and for you advisors, and how you work with your clients. Bill, what do you do in terms of recommending next steps to your entrepreneurs about how they find their employees, how they find their advisors, how do they do the vetting, what protections can they put in place, how do they make sure they're going into business with the right people and finding people who are going to build their business and not detract from it?
Yeah, it's not easy, Jay. I mean, I talk to the multiple, the serial founders, and I talk to them about their hiring strategies and what they do. And some of the people that I respect the most say, I vet everybody 3 times. I have them interview everybody on the team. I ask them probing questions. I check their references, and half the time it won't work out. There is a dramatic amount of uncertainty in the early stages of a company, and most people can't handle that. It's not an insult. I'm not trying to impugn anyone. It is simply that operating in a world with no defined boundaries leaves most people really, really uncomfortable. And so really smart people, you can take that 4.0 student from an Ivy League school and you can plop them into a startup and you can watch them drown immediately, because nobody set up the guardrails, nobody's told them what they're supposed to do, and they struggle to suss it out. So I really try to, when I interview people, I try to assess their experience with uncertainty, their experience with poorly defined problems and boundaries, and see how well that works. But then I end up at the point where I think my colleague who says 50% won't work out is probably about right. And so then you get to the question of, like, how do you move people along in the interest of the company, and when do you do that? And I guess the way you do it is probably pretty quick and pretty clean. In the startup world, you don't really have 3 months to give somebody a performance improvement plan. And if they're not hitting on all cylinders, it's probably not something that you can teach them. It's probably more to do with their personality and again, that uncertainty question. My experience is I have never yet fired anybody too soon. But everybody I've fired too late. And the thing people don't understand in a startup is how much of an enemy time is, especially people who come from academia, where time is almost free. You go into a startup and my engineers, every young engineer I've worked with in my career has come to me and said, "Hey, Bill, I saved us $100." And I said, "How's that?" He said, "Oh, well, they wanted me to pay for expedited shipping, but I got the week shipping instead and saved us $100." And I'm like, "Well, the company burns $3,000 a day keeping the lights on, and you just delayed the project by a week. You didn't save us a penny." And the good engineers learn that kind of lesson on day one, and the bad ones don't learn it, and you got to move on. So um, I think you kind of have to be slow to trust. You have to look at people and really be explicit about values and expectations and get that all out on the table. You have to have a really simple, straightforward plan to unwind people when they don't work. And you have to do that and maintain a culture of support and confidence as well. So it's a really fine line. I will go back to what was said before. Everything needs to be in clear legal agreements, IP assignment, all of that stuff. There has to be no subtlety, no confusion about any of that. I've had contractors try to tell me that they should own the rights to all the code they create on my dime. And I was like, no, that's not going to happen. And they're like, oh, but that's standard. I said, well, you're not working for me, then move along. So it's really about managing your human side and really wanting to support people and have them grow, but also being pretty distinct that the success of the company depends on rapid action and hard decision making. And it's more of an art than a science, but I think everybody else on the panel has laid out the legal issues, and they're foundational, and you build everything else off of them.
Yeah. Matt, Bill sort of alluded to this, at the exit, at the M&A, the strategic collaboration, if you could go back in time, what would you have wished that the companies had put in place on day one to facilitate the exit?
Yeah, a lot of it is, like I said before, is be very boring on the legal side. If everyone has properly signed the proprietary information invention assignment agreements, they've all done as part of their capital contribution, any existing IP the founders had before starting the company, which can be often overlooked. And that is what is the best way to smooth things out. Other than that, and that's probably your main thing, is making sure everyone was properly incentivized to keep going. Like my colleagues were saying on the equity side, are they going to be contributing on an ongoing basis? Well, make sure that they are properly incentivized in order to do that. At the end of the day, you need to have a business to worry about, because if you don't have the business, then all the legal protections only help you so much.
That's a great segue into something that I was going to ask. And so thank you, Matt, for setting me up and throwing me that softball. Ed Pease, if I could ask you to talk a little bit about the difference between options and restricted stock, and when you can use those two tools, when you should, and if you could talk about vesting and how that applies to options and restricted stock, and how vesting should be used as a motivating tool along the lines of what Matt was sort of starting to get into.
Yeah, very quickly, given where we are on time. So we want to use equity to incent our employees. And the two main ways we're going to do that is to give them options or restricted stock, both of which should typically vest over time. They may vest just on time based. They may vest on performance based. You can be creative there with vesting, but Ed will tell us about vesting in a minute. Vesting, very important. And what's going to drive which of those two I can give you is going to be the value of the company and what the tax implications of what I give you are. Stock options basically designed to be granted at the fair market value as determined by the board of directors, such that when I present an option to someone, it has no present value, because you would pay exactly what the stock was worth in order to exercise the option if it were exercisable. So meant to help you participate in any upside above that value as you build value in the company. On the restricted stock front, if the company, if the value per share is low enough, I can give you shares of restricted stock and have you either pay for them or have the tax implication of being awarded those shares. The IRS would treat a grant of restricted stock just like it would compensation. So if I gave you $1 million worth of restricted stock, you're going to have $1 million worth of income that you're going to have to deal with. So restricted stock really only works if the person's actually going to pay for it, doesn't mind paying the taxes for it, or the price is low enough that paying for it is not overly onerous. And the difference, and as an optionee, I only have a right to buy shares in the future by paying the exercise price, whereas restricted stock, I'm going to pay for it now, become a stockholder, have all the rights of a stockholder, the right to vote, etc. And the company would have the right to buy back those shares in the future, thanks to my vesting schedule. Over to you on vesting, Ed.
Yep.
Yeah.
And investing, as Ed said, it's really the same in any of these instruments. Mechanically, it works a little bit different, because if you have an option, which is just a contractual right to buy equity once it vests, and you are terminated, that contractual right just goes poof with respect to the unvested options. You might have a limited window to exercise options that have already vested. If you've received equity restricted stock and you leave the company before it vests, the company will actually have to repurchase it. And usually it's for the lower of cost or fair market value. There are different ways where the repurchase price is calculated, but you actually have to repurchase equity because the restricted stockholder owns the shares at that point. But equity fundamentally is just a way of ensuring that the recipient of the incentive equity does what he or she promised to do, or what they agreed they would do in order to earn the equity. For some employees, it's just a matter of time. 4 years tends to be the typical schedule, as Bill said earlier, often with a 1-year cliff. So none of the equity vests until you've been at the company a year, and then typically vesting monthly or quarterly after that. But you can customize it any way you want. As Ed said, there's performance-based vesting, which maybe if the employee is coming in as a business officer and they've promised to go be able to help fundraising, you might say, okay, well, some of your shares vest over time, but others vest when you go out and you raise 5, 10 million, whatever the number is. And there could be a sunset. So you have to raise the money by then if you want that equity to vest. For, a CEO, it could be, you have to get us to a successful partnering transaction or exit event at a certain point, and a portion of your equity is going to vest based on that. You can really customize the vesting however you like, but again, it all comes down to what was a business agreement in terms of what the employees said they understood they would need to do in order to earn the equity.
Great. Well, everybody, thank you so much for an engaging discussion. We've got to end here. We've reached the end of our time. But everybody in the audience, thank you for joining us. And a big thanks to Ed Amer of Goodwin, Bill Walker, Matt Ferry of Morrison and Forrester, Ed Pease of Mintz. Really appreciate your thoughts. Really fascinating discussion today. To all of you in the audience, please join us again on October 7th for our next session entitled Funding a Life Sciences Company. It's been our pleasure.
Thank you.
Thanks, Jay.
Thanks, Jay.